is not the entity having more than 100 crore or 500 crore of say size of that particular organization, and them facing say penalty or legal liability of say even 10 crore 15 crore may entirely crumple that particular MSME. But we must understand this is the highest limit, 250 crore. It is
Right.
not that it will be a rule that everybody will be penalized with 250 crore. It
Yeah.
may depend upon the quantum of damages which have
Right.
been inflicted on data principal. So I am satisfied with these penalties, and being a legal professional, if I get a client for fighting for 250 crore, I'll be really happy, more than happy.
Yeah, yeah, yeah. Even if you are paid 1% of that, that will justify the.
More than happy.
All right, all right. And so I think as a last question before we move on to the audience questions, Dr. Limaye, since you mentioned 10,000 rupee penalty for data principals in case they don't follow the duties. So I think this is a very this is a something that applies to all of us as individuals, as data principals. So if you could articulate what are the duties of data principals which we need to follow, and if we do not follow, 10,000 rupee penalty can be inflicted upon all of us as well as data principals. So over to you, Dr.
Yeah, so the section prescribes what is the duties. They should not give any fraudulent information, or
Hmm.
they should not cheat while giving the information. That is only broadly mentioned. So whatever information or whatever consent they are giving, the information provided through that particular consent or through that particular acceptance of notice should be correct information, fair information, and there should not be any fraudulent angle to providing that particular information. So if you provide your information legally correct, then data principal will not subject to this sort of punishment. But deliberately, if you are misleading someone by opening say false social media accounts or giving false telephone numbers to harass someone, then these penalties will be attracted towards those data principal. So basically, if data principal remain say providing genuine information, and which I believe Indian data principals are fair enough for providing information in a reasonable correct manner, so I don't think Indian data principal will have to suffer. But as a legal person, I certainly have some say queries or some questions in my mind, that can duties be taxed if non breach of duty, if our constitution doesn't penalize for non breaching of fundamental duties cast on the citizen, why these duties which are under DPDP should be penalized? So there is some sort of legal debate which I have in my mind. But yes, I presume that the penalties prescribed are reasonable enough, because due to which again significant data fiduciaries can be put at some risk or at some damage, and that's why this 10,000 is fair enough. How much it will be applicable or it will be enforced, let's see, because unless DPB comes in a reality, and what Samir addressed, that if he presumes that it will be, or what we are waiting at, it will come shortly, if it happens soon, then there will be reasonable good framework for DPB, Data Protection Board in India. So I think duties are fair enough, and data principal, if they provide true and sincere information, nothing to worry about.
Yeah, yeah, absolutely. And I was reading section 15 of the Act saying duties of data principal. So it just to read a couple of important words, it says to ensure not to impersonate another person while providing her personal data for a specified purpose. So of course that being an imposter or impersonating or fake accounts, in case those accounts in future are linked with certain illegal activity or any other thing, that impersonation may sort of cost. Similarly, not to suppress any material information while providing our personal data, like any, or not to provide a false information, as Dr. Limaye also said, proof of identity, proof of address, etc. And one important point is to ensure not to register a false or a frivolous grievance or a complaint with a data fiduciary or the data protection board. So, in case there is a frivolous grievance reported by a data principal, there also you may be penalized. Okay, so that's on the rights of the data, rights and duties of data fiduciaries, duties of the data principals. data, sensitive personal data, data protection board. By the way, the law envisages the establishment of a data protection board, which board is not set up right now. But what we understand is it should be very quickly set up in the next few months, maybe 2 months, 3 months, time will tell. And then when the data protection board comes, will then probably they frame the rules, because this requires a lot of now rules to be framed under so many sections to give the practical governance and application to that. And all the complaints or grievances under the law, I think, will first go to the data protection officer, and then the complaints will go to the data protection board, right, Dr. Limaye?
First, it has to be settled by DPO or grievance officer, whatever is available with that particular company.
Right.
And if aggrieved by that particular decision, then
Yeah.
it can go to DPB, means Data Protection Board. And after DPB, it will go to TDSAT. So
TD.
mechanism is prescribed, but unless DPB is there, don't talk about what are the higher appellate authorities, but those are already prescribed.
Yeah. So while DPB, Data Protection Board, is expected to come soon, and they'll also finalize the rules, etc. The TDSAT has always been existing for TRI disputes, even for the IT Act Appellate Tribunal. TD Telecom Dispute Appellate Tribunal has always been there. So same is the appellate body here. And Dr. Limaye, as we were discussing, the appeals from TDSAT will straight away go to the Supreme Court, right?
Yeah, as per TRAI it goes to, but in IT Act it goes to High Court.
Right. But here they say the appeals of TDSAT will be as per the TRAI Act.
So then it will go to Supreme Court, because TRAI directly goes to Supreme Court.
Right. So I think we see a whole lot of new legislation coming up, opening up new opportunities for practicing professionals also, to sort of not only do awareness sessions and investigations on data privacy or advisory consulting opinion, and not just practicing professionals, I would say even the in-house professionals, to advise their managements on their privacy issues and the consent and the notices, and in case any complaint, and to also act like data privacy officers or grievance officers, and in case any disputes were to arise, to also represent before the Data Protection Board or the TDSAT or the Supreme Court. So I think a whole new bunch of sort of laws and governance and jurisprudence will emerge out of this law, and it's going to be very
Sumit, just I want to interrupt for a moment.
Yeah.
There are additional two emerging opportunities for the audience who are here. One is data protection impact assessment, what Samir has previously mentioned, that every organization will be required to carry out data protection impact assessment. That will be opening enormous opportunities to take guys, carry out data audit. And another, which is very what each and every participant should focus on, is consent manager. That is totally emerging new concept in our DPDP, that the consent manager can be able to garner the consent of n number of data principals, and he will have that collective bargaining power of this many data principals. So that is totally new concept, that is consent manager and data protection impact assessment. Apart from DPO, we have two new concepts in our Indian Data Protection Act, where consent manager is for the first time discussed, who will collectively represent the data principals to the data protection board or to that particular committee. Like many times we see data breach happens with the big companies and individual cannot fight. In Consumer Protection Act, we have that particular provision now, that is class representation. Same concept is now modified into DPDP, and consent manager is the new consent or new terminology which will be in process future. So those who are in this particular seminar can also look for this particular two additional opportunity. DPO is already highlighted, data protection impact assessment and consent manager. So emerging or various opportunities will emerge for legal and technology professionals out of this particular DPDP. That was only what I wanted to add.
very nicely put.
I also want to add one very important point from data, the rights of the data principal, that we have a right to correction, completion, updation, and deletion of her personal data by DF, which means that I order a pizza from Zomato and I give them a consent and I give them a very clear purpose, which is delivery of food at my home, and I give them 1 hour, and I have a right to go after that to Zomato that I buy pizza only once in a year. I have given you consent for delivery of pizza, which has come. Very good. Thank you. Now delete my data.
Yeah.
And the next time I want to order pizza, I will again create a user and again give you consent. So the purpose and duration is there.
Right, right. No, very nicely. This is also very, very important point, Samir. I agree. Right to be forgotten, as has been sort of communicated, that
No, Sumit, right to forgotten is not there. Right to delete is there. Forgotten was there in the previous version. GDPR has the word forgotten.
Right,
In
right.
our DPDP, the word forgotten has been
Erasure.
it has been said right to deletion. Deletion and forgotten means deletion is a temporary activity and forgotten is a lifelong activity. So forgotten word has been removed from this one. So I saw some HR professionals also here. So they need to understand that I come out with a new JD for a new vacancy, and I get some 100 CVs, out of which I shortlist 20 and I interview 20 and hire one person. Now the rest 99 have a right to come back to me and say delete my data. I gave interview, you did not. I gave you consent only for being interviewed, and if selected, take me on board.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.